Good afternoon. We have 4.5 hours of argument time requested, so ask for the time that you need, not the time you wish. We're familiar with the briefs and the records, and if we have more questions, we will keep asking them. People versus Cabrera is submitted. Abrams versus Abrams. I'm going to give you 3 minutes to argue, okay? McCoy versus Zanville B. Appellant? Is anyone else here? Do you still want to argue then? Okay, I'll give you 3 minutes, and if we have more questions, we'll keep asking. Hassan versus Maserik Company, appellant?
Appellate ABC request 4 and 3.
Appellant?
3 of 2, Your Honor.
Plaintiff?
Request
5?
5. 5, yes.
Okay, 4, 3, 3, 2, and 5. People versus Rakim?
The people concede all 3 issues in the brief. Unless the court has any questions, I'll submit.
I don't think we have any questions. Thank you. Cooper versus Arbor Realty Trust, appellant?
Appellate request 4 and 3, Your Honor.
Respondent Maurice Kaufman, 5, Your Honor.
4, 3, and 5. Wait, I'm sorry. Who are the 3 people then?
There are 2 respondents, Your Honor.
Okay.
Respondent Kaufman and Respondent Arbor.
Does Kaufman have separate arguments? Are you here for Kaufman? Do you have separate arguments you're making?
Yes, Your Honor.
Okay, 4, 3, 5, and 4 for Kaufman. Goon versus Grand Central Partnership, appellant? And I know there are 3 respondents. Right, how much time are you requesting? Okay. How much? 3 minutes. 3. Okay, 5, 2, 5, 3, and 3. People versus Joda? Respondent? 6, 1, and 6. McCoy versus Lavski, appellant? Respondent?
Good afternoon, Your Honor. Respondent Lavski and Bronx, Lebanon, we request 5 minutes, Your Honor. Respondent McCoy requests 5 minutes.
5, 2, 5, and 5. American Infertility of New York versus Kushner, appellant? I guess appellant is not here. Do you wish to argue?
5 minutes.
I'll give you 3. If we have more, we'll ask. People versus Lounis, appellant?
Appellate request 5 minutes and 2 for rebuttal.
Respondent request 3, Your Honor.
5, 2, and 3. AT&T Mobility versus Grupo Lounis is submitted. So the first case for argument is Abrams versus Abrams. Go ahead.
Good afternoon. Thank you for having me. I'm representing Pro Se as the appellant. This is a very simple 2-page purchase memorandum and then an arbitration agreement where petitioner could not get certain entities to agree to arbitration, namely the Aracar entities and Sandra Piedra Buena. They refused a notice of arbitration. They refused to sign an arbitration agreement. And unfortunately, the arbitrator decided then to allow them to add 17 entities, including Sandra Piedra Buena, to a statement of claim, even though they'd refused arbitration.
But didn't the arbitrator dismiss the claims against Sandra?
He ruled at the very end, he had the authority to compel her to arbitration, dismissed it, but stated specifically he could still find that she could be liable for collections.
Well, you can't represent her, can you? You're not an attorney.
No, I cannot represent her. But what is clear is the contract law is clear, as I was only a guarantor of the contract. I am not a party to the contract. It is explicit in the purchase memorandum. I only agreed to arbitration based on who the parties were to the arbitration agreement. I was not compelled to arbitration because I was not a signatory to the underlying contract. This was agreed in advance, and then the arbitration agreement was effectively thrown out. There was no meeting of the minds by saying we're going to add 17 other entities, and the arbitrator, as First Kaplan had warned, arbitrability is only decided by a court. It was a unanimous decision, and it was based on the arbitrator as a financial interest in making an arbitration more complex. I didn't agree to have those entities explicitly, and rather than the arbitrator simply say to petitioner, go get a court order to require them, or drop them. That's the public policy issue where there's a giant red line. I would say I did find recently Trina Solar versus Jasmine Solar was decided in the Second Circuit, reversed. Southern District affirmed almost a similar thing where there was a personal guarantee by a parent company written in a contract. They were not a party to the contract.
Are you arguing on behalf of the entities?
I'm arguing on behalf of myself as a guarantor in the agreement that I'm not a signatory to. And I'm saying this was a very similar case. The arbitration gets tremendous deference at the lower court. The circuit court ruled de novo decision that this was not an actual party defined in the contract, and the personal guarantee does not follow the statute of frauds, which is a very clear line. You have to personally sign an agreement to be a personal guarantor in a contract. The only decision found by the arbitrator against me was a personal guarantee on an agreement I did not sign
Thank
in
you.
a personal capacity.
Thank you very much. Juan versus Zanville.
Good afternoon, Your Honors, and may it please the Court, I'm Leah Edmonds of the Children's Law Center, appearing on behalf of the child who is now 10 years old. This is an appeal that cries out for remittal for multiple reasons. The court clearly did not consider the child's best interests in the proceedings below. The father's attorney clearly did not provide him with adequate representation, but it is also very pressing that I let you know that yesterday, my colleague spoke to the child, and this was an in-person interview for the first time in many months. And the child revealed that the mother has been using excessive corporal punishment, including hitting the child with objects and causing bruises and bleeding. The mother has forced the child to eat until he got sick to his stomach. She has hovered while he's having his court-ordered calls with the father so that the child can't speak freely. She has abused the child's pets, including withholding food. And we just learned that when the child stated at the conclusion of the proceedings below that he was happy with both parents, that things were better with the mother, that he wanted to live with both the mother and the father, in fact, the mother had told him that she would take away his pets if he did not say that to the judge and to his attorney. Therefore, these circumstances alone really cry out for remittance for a full hearing concerning the child's best interests.
Thank you. Does anyone have any questions? Thank you for the update.
Thank you, Your Honors. And I will just say also that it is very clear that the court below applied an inappropriate standard. It recited a standard that's only applicable in neglect proceedings and clearly did not. The court mentioned the term best interest several times, but really failed to conduct a hearing that in any way explicated the child's best interests.
This is the horse to record, but do you know if that judge is still on the bench?
I believe that she is, yes.
Okay. And has any request been made to send it to another judge?
We did not make that request in our brief, although we would certainly request that, not that it's necessarily our place to ask, but we do believe that it would be appropriate for the father to be appointed a different attorney. a different 18B attorney.
Okay, thank you very much.
Thanks very much.
Hassan versus Maserik Company?
May it please the court, Michael Kazoras from the Law Office of Eric D. Feldman for the appellant respondent ABC Imaging. There's several arguments to be addressed. I'm sure your honors are very familiar with the issues. The first one is whether the plaintiff was properly granted summary judgment on his claim under Labor Law 240. We believe that at a minimum, it's an issue of fact, but we also believe that this claim not only should not have been awarded summary judgment to plaintiff, but that the claim should have been dismissed.
Why isn't this a classic case of the ladder being inadequate for the job, since the pictures do clearly show that the plaintiff had to reach in a way that he shouldn't have had to reach to be able to do the work?
Because he didn't fall when he was reaching. We concede that perhaps that ladder was not the best instrument to do what he was doing, but he wasn't injured when he was doing the work. He was injured when he was moving the ladder from one location
Counsel,
to another.
actually, the evidence doesn't, I know that's one of your arguments, but what evidence is there concretely in the record that he was actually wiggling the ladder at the
Well, it's
time of the
the
accident?
video.
The video shows him wiggling before the accident. It doesn't show him wiggling at the time of the accident, and he says he wasn't wiggling at the time.
The video shows the base of the ladder at the moment of the accident, and it's wiggling in the exact same manner that it shows him wiggling it when it's undisputed that he's on the ladder. You see him on top of the ladder wiggling
How
it.
can you make that distinction of whether it's the same conduct as walking the ladder versus the ladder was tipping over?
The ladder is making the
The
exact same
testimony, the
movements.
testimony the plaintiff gives is that he walked the ladder, but it was something like 30 seconds before the fall, and he specifically said that he was not walking the ladder when the incident happened.
But the video shows that the base of the ladder was moving in the exact
the
same
ladder was
manner
falling.
as it was. So that creates an issue of fact as to whether or not he was
Counsel,
walking
even
the
if
ladder.
He was wiggling the ladder, which I'm not sure that that can be shown, but even if he was, isn't the law clear that when you're doing something at the direction of your supervisor, then you can't be the sole proximate cause? And isn't there clear, undisputed testimony from the plaintiff that his supervisor had in fact instructed him to wiggle the ladder to move it, and that he was following instructions of his supervisor in moving the ladder in the way he did?
That is correct, but that supervisor had testified that he told the plaintiff never to walk the ladder, not
That's not really accurate. From what I remember is that McGrath testified that he provided instructions to the workers not to walk the ladder because, you know, he heard from other people that they were doing so.
Correct.
But I don't think there was anything in the record to say that the plaintiff was present when he gave these instructions. He certainly didn't say the plaintiff was there and I told the plaintiff.
He said that he told his men, the workers.
Are you circumventing what the question that was just asked, counsel?
I think so.
I didn't think I was.
Okay, let's go back to the height difference. The photographs are pretty telling. The plaintiff testifies that he had to place, what's the name of this?
Jerry board?
Jerry board, right. He had to place jerry board, and when you take a look at the height differential that you can see within those pictures, it's clear that the ladder's height is inadequate. How do you possibly get around that?
Because he wasn't injured when he was doing that work. He was injured when he was moving the ladder. His feet should have been on the floor when he had his accident.
Well, if his feet were on the floor, he wouldn't have been able to reach up but 6 feet or so, right?
Well, but he wasn't, he was moving the ladder. He wasn't putting the jerry.
There's no testimony to that effect.
Thank you.
Thank you.
Good afternoon, Your Honor. Seth Weinberg for the Maserik defendants. And with the court's permission, I'd like to transition from 240 to the indemnity claims. that are at issue here, and particularly with our appeal regarding the failure to procure insurance claim. This court has held that submitting a certificate of insurance is insufficient to establish a prima facie burden to dismiss this claim, and that's the only piece of evidence that ABC submitted in support of
Your
their motion.
argument is that the court erred in granting summary judgment on this issue because at a minimum, there's issues of fact as to whether or not this insurance was or was not obtained.
Correct. They didn't meet their prima facie burden because they didn't establish the insurance was procured. They
We
established a
have certainly
certificate.
held that a certificate insurance is not enough.
I'm sorry, Your Honor?
We have certainly held that a certificate insurance is not enough.
Correct, Your Honor. And if I can just briefly transition to their other argument concerning the enforceability of the contract. The contract itself was signed after the accident. There's no dispute. But the contract on its face says the term of the contract predates the accident. And it's ABC's argument that the employee who signed it for them didn't know what that meant, didn't realize it was there.
Counsel, we routinely allow those kind of contracts to be enforced. There's nothing in the law that prohibits those type of contracts from being enforceable. And the mere fact that someone didn't read a provision in the contract certainly doesn't render it unenforceable. So why shouldn't we enforce that provision since it's a legally enforceable provision?
I think you should, and I think you should affirm the court's order
Oh, you're saying
doing
that you're, I'm sorry, you're
That's
arguing
okay.
we should enforce it.
You said it better than I did, Your Honor.
I'm glad I made your argument for you. I'm so helpful.
And with that, I will sit down unless the court has any other helpful questions for me. Thank you very much.
No, you're not going to argue about that point.
I hope you make the argument for me too, but
I thought we already did.
Brian Isaac, I represent the plaintiff respondent. Your Honor, if you look at the video, the funny thing about the video is the first video is his supervisor wiggling the ladder exactly like he said. And I'm just laughing because on 819 of the record, this is Mr. Junior's affidavit, undisputed. During the evening, I used the same ladder that Mr. Hassan was on when he fell. As is our custom, I would move the ladder by wiggling it along the side of the barricade wall while I was on the ladder. During the evening, I saw Mr. Hassan move the ladder the same way as I did. ABC told supervisors to train helpers while we were in the field on the job sites, and I did so by example. He was following the lead of his supervisor. He can't possibly be the sole proximate cause, and you saw him on that video. I mean, what's miraculous here is not that he fell. It's miraculous he didn't fall before. He's straddling the ladder, and there's one point where he's on one leg doing a pistol squat with no fall protection at all, and he jumps back. He's like a tremendous athlete. So this is a perfect liability claim. And Judge Kennedy, with respect to your question, Mr. McGrath never, not once, said he said anything to this plaintiff. As a matter of fact, the words he used was the plaintiff didn't get any training because he was pre-trained based upon his previous experience. So there is no evidence that this plaintiff did anything other than follow the instructions and mandates of his employer. It's a perfect liability case, and the trial court got this one exactly right.
And I know that the security officer submitted an accident report saying that the plaintiff did wiggle the ladder, but he didn't even witness the accident. It was only the plaintiff and his supervisor that were there.
That's absolutely correct, undisputed. Thanks for listening.
We're all making your arguments for everybody.
Thank you.
Your Honors, with respect to the barricade agreement, it's undisputed that it was signed afterwards, and the case law is pretty clear that if the parties are still negotiating the contract after the accident, that there's at least an issue as to whether or not it should have taken effect on the day it was signed.
Not, usually goes to the reading the agreement itself. Is the contract ambiguous? Is it not ambiguous? And where is there any ambiguity in this particular contract about when it would be enforceable?
I think the surrounding circumstances creates an ambiguity. On page 1346 of the record, there's an email from between Maserik and ABC talking about finalizing the negotiations.
Why would we be looking to emails, though, unless there's some ambiguity in the agreement itself? So I guess the first place we should start is there any ambiguity in the agreement itself about the dates that it would be effective?
Not in the writing itself, but I
So
think.
why would we, if there's no ambiguity in the writing itself, we would never look at parole evidence to determine if there's an ambiguity, right?
Well, in this instance, I think you should, given the testimony of the parties and the correspondence between them before the agreement was signed. Thank you.
Thank you.
We would submit the contract clear on its face. That's what the court should read and enforce the provision accordingly. And unless the court has any other questions, we'll happily rest on our brief.
It's clear on the first page of the contract, yes?
First page, second or third paragraph, and it's not denied it was inserted before it was sent for signature. No one's claiming that, you know, someone pulled a fraud or tried to do something untoward. It's just this gentleman didn't think to look for it.
Thank you very much.
Thank you.
Cooper versus Arbor Realty Trust.
Good afternoon, Your Honors. May it please the court. Daniel Field of Herrick Feinstein. We represent the appellant on this appeal, Mr. Adam Cooper. Your Honors, the trial court erred in its dismissal of Mr.
Well, it's clear he's not a broker.
Excuse me?
Clear he's not a broker, a licensed broker, Mr. Cooper.
That's correct.
Okay, and it's clear that you don't really dispute the import of Real Property Law 442-D.
We don't dispute the import of RPL 442-D, but I would like to point out, Your Honor, that RPL 442-D does not apply in this situation. I want to explain why.
Well, because he's claiming he made a match, like a wedding.
That's
He
correct.
made a match.
But
And therefore, he should get over $1 million.
we're claiming that he is entitled to a finder's fee based on the services that he provided. But the reason I want to address that point,
Well,
Your
counsel, didn't Mr. Cooper receive a finder's fee from, is it Moishi?
from Emerald Empire, Your Honor,
From Emerald Empire?
in connection with one deal.
Yes, but he was told clearly that this would be for one deal only, not for each subsequent deal. So if he received a finder's fee for introducing one party to the other, isn't that the end of it?
Respectfully, it's not, Your Honor, because I'd like to point out, I mean, in Mr. Kaufman's own words, what respondents promised would be paid to Mr. Cooper. And in this situation, the terms of the agreement are that respondents agreed to pay a finder's fee to Mr. Cooper in connection with any agency loans.
Are you relying on an extensive series of text messages that were part of Mr. Cooper's affidavit? Are you relying to get around the statute of frauds? 'Cause you can't get anything under the statute. So in order to get around the statute of frauds or claim that these different text messages between Mr. Cooper and Mr. Kaufman, without any kind of subscription block or anything indicating, you know, that whole back and forth that we all plowed through, that's the writing that confirms your deal?
We are, Your Honor, but I'd like to point out that within that writing, you specifically have the subject matter of the agreement, the parties to the agreement, and under this written agreement, the respondents agreed to pay.
Counsel, he asked you a very specific question, my colleague, which was about the signature, because cases clearly require that it be subscribed, and the only way that can happen under the case law when it's emails, if there's some kind of signature block or something indicating the signature. So what are you relying on in this particular case to support your argument that there is, in fact, the equivalent of some type of signature on these emails?
If permissible, Your Honor, I'd like to address that in two parts. And just the first thing I'd like to point out that the subscription argument, I'm going to make this brief, the subscription argument that was raised by respondents on appeal, this is the first time they've ever raised that. This wasn't raised in their motion to dismiss. They raised new arguments in connection with the subscription argument. And under the precedent of this court, those are in fact improper. But I'd like to address the second
Well,
part.
actually, we're allowed to, go ahead, but we're allowed to, even if that's true, we're allowed to hear things on appeal if it can be resolved without any factual issues, which this would be just looking at the agreements. But go ahead with your second argument.
Understood. But I would just also like to point out that in connection with that argument, and this also does relate to our argument that our request for a continuance and to replead was improperly denied, I'd like to point out that the Second Department, relying on the Court of Appeals, has expressly held that in connection with situations where there's multiple writings, i.e. that are trying to determine whether multiple writings can satisfy the statute of frauds, the Second Department, relying on the Court of Appeals, has expressly permitted the courts to rely on parole evidence to determine whether or not the party who is supposed to be subscribing the agreement or the party to be charged did in fact assent to the agreement.
I'm going to let you give us that side on rebuttal, but let's hear from.
Understood.
Good afternoon, Your Honors. May it please the Court, on behalf of the defendant respondent, Maurice Kaufman, Donnie Schwartz of Offit Kerman, I'd like, if I may, to turn immediately to the issue of subscription of text messages that Justice Schulman first raised.
Counsel, why don't you take off where your adversary was just left off? What about that case?
Forgive me, Your Honor, could refresh my recollection as to the name of the case?
Well, he would have to do that.
He didn't give us the name.
He didn't give you the name.
Website yet.
Well, look, what we've called...
I think the import of it was that in terms of the subscription, that you could refer to other evidence to see what the intent was. What's your response to that?
Sure. Well, as a practical matter, if this court were to ignore the glaring and obvious fact, which is a purely legal issue apparent on the face of the record, that not one of the 40 pages of text messages were subscribed, and reverse without giving
This is not a case where some text messages had a subscription and others did, and none of them did.
Correct. 40 pages, hundreds, countless texts. Not
What about
one
the argument that in today's day and age that's acceptable? That's the way that people text today.
Sure, that's a terrible argument, respectfully, Your Honor. First of all, it's in the statute of frauds itself. The legislator passed it. It's in the statutory language that the writing has to be subscribed. And second of all, oftentimes the flippant, shorthand, abbreviation, and incoherent, sometimes text messages that were illustrated in the 40 pages here in the record are the best argument I could possibly offer as to why this court should not, by judicial fiat today, change the statute of frauds and not require text messages to be subscribed.
When it comes to determining the writings, you need all the relevant parties in the writings. Was Arbor mentioned anywhere?
Rarely, Your Honor, over a period of 2 years in what I've called the hodgepodge.
And certainly there was no indication writing the Morris was speaking on behalf of them, on behalf of the company.
Clearly, if there had been a contract, a writing with all the parties to be charged, even an email, that issue would not have been so murky at best.
And of course, the essential term in terms of the actual fee, that wasn't really clear from all 40 pages.
Not only was it not clear, Your Honor, the plaintiff, the appellant, is suing for a 25 basis point or 0.25% commission. That price term is not mentioned anywhere in the 40 pages of text messages.
So let me approach this from a different angle. Does this boil down to one friend taking advantage of another and leading them on and saying, yeah, help me, or oh, I'd love if you did this, and then giving nothing in return? Or does this fall under the rubric of the RPL, where it says at 442-D, unless you're a broker, you don't get a commission. You use the term commission. I assume it was intentionally.
Correct, Your Honor. As between those two choices, I would say this case certainly falls under the latter rubric. In the first instance, Mr. Cooper, the appellant, did receive a fee from Emerald that he negotiated in an agreement, which is alluded to in the complaint that itself was in writing. And in the second place, if you're not a licensed broker, then you shouldn't be acting as one, and that's exactly what the statute and the attendant case law holds.
It's my understanding that Cooper was offered, I think it was $100,000 or something in that ballpark to settle, for lack of a better word. Doesn't that go towards intent?
No. Well, first, Your Honor, I think under the CPLR that an offer of settlement is not admissible to prove liability. But the reality is that since Your Honor asked about it, that on behalf of Mr. Kaufman, he was willing to pay or offer a somewhat significant sum to make this, if I may just finish my sentence, to make this lawsuit and the litigation and the costs of that disappear, including paying for an appeal now. So to him, that would have been worth it. But that offer.
Counsel, if I may, very quickly, You know, I know that Mr. Cooper is relying on, I believe it's a July 2022 text regarding the argument that the parties agreed on a fee. But was there ever any, you know, clear discussion about how much would be paid in that text?
No, Your Honor. There was a lot of disagreement about what wasn't, going to be paid or what should or shouldn't be paid. But there was never any agreement. There was never a mention of 25 basis points. And because of that, the case law clearly holds there was no meeting of the minds.
Thank you very much.
Thank you.
Good afternoon. Your Honors, there are several independent reasons, dispositive reasons why this appeal fails. Justice Kern, the first is the one you raised, which is 444D. I don't think it's disputed that this is a real estate transaction. It was a $417 million transaction on multiple pieces of real estate. So the only question is whether or not the defendant's actions constitute the actions that need to qualify to be a real estate broker. And all you need to do is look at the appellant's pleading. And I'd urge the court to focus on, in the record 28 and 29, paragraphs 80 and 84 of the complaint. Paragraph 80 says, plaintiff performed all obligations required of him pursuant to the finder's fee agreement and specifically caused Emerald to borrow $417 million from Arbor. He didn't just introduce. This wasn't just an introduction, a wedding introduction. He caused the deal to happen.
So how is that different? How does that fall outside the purview of 442-D?
It doesn't. It's covered by that. It's covered by that statute, and because it's covered by that statute, the appellant was required to be a licensed broker, which he acknowledges he's not.
We don't even need to get to the statute of fraud, that you win under
Yeah,
442G, and that's the end of the story.
Yeah.
I got you mixed up as to who you were.
Yeah. No, we have two respondents, and
Is there
record
any real
29,
dispute-
paragraph
is there
84.
any
I'm sorry.
Is there any real dispute as to whether or not this involves a real estate transaction?
No, I don't think appellant disputes that. I mean, it's a $417 million financing for several buildings. I mean, that is obviously a real estate dispute. The appellant also pleaded that he facilitated the transaction, and that's on the record 29, paragraph 84. So there's no dispute there. There's also no dispute that the text messages, to the extent appellant is claiming they were a written agreement, which is required, that they weren't subscribed. There is not, on one text chain, Your Honor, there is not one signature block with the name of Arbor or Mr. Cooper on any of the text messages, literally not one. You can't go outside of the documents to define that. Under the law, it has to be in the documents. So that is also a separate independent reason. We do have the right, even though it wasn't specifically raised below, to raise it here under this court's precedent, Basu against Alphabet Management, which is 127 AD 3rd 450. It's a legal argument based on what's in the record, and as Your Honor said, it would resolve the issue going forward. So the last thing I just say, the last thing is that.
Counsel. If one of us
I'm
asks
done.
a question,
I'm done, Your Honor.
You have to let us ask the questions.
Oh,
You
I'm
can
sorry.
answer it. It's okay. Forget about it. But if we stop to ask a question, let us.
I didn't hear you. I'm sorry. Is that it?
Yes, that's it.
Thank you very much.
Thank you.
Your Honors, two brief
Did you find
points.
that site? Did you find that site?
Yes, to the case that I was referring to earlier. The case is McCoy versus Paisano, and we cite that in our reply brief, Your Honor. But I would like to note.
No, what's the site?
Oh, the site. I'm sorry. 95 New York State 3rd 125, and that was affirmed by the Second Department. The Second Department site is 185 AD 3rd 915.
And, tell us what the case is, because I'm a little confused, because the law seems pretty clear that you need a writing subscribed by the party to be charged, and the whole idea is that it's a statute of fraud. So You're saying the case says you don't need a writing, you can look at other evidence to see the party's intent?
No,
Wouldn't that undercut the whole purpose of a statute of fraud?
Respectfully, Your Honor, we're not saying that a writing is not required. We are saying that the writing requirements were met here. Now, in connection with this,
Wait, but what does the case exactly say about subscriptions?
the case that I'm referring to specifically says that, well, it's twofold. First, that parole evidence you can look to parole evidence to determine whether the party to be charged did in fact assent to the agreement, but
that wouldn't go to the signing, so go ahead.
But also in connection with that argument, the reason I raised our two additional arguments that our request for a continuance should have been granted, as should our request to...
Counsel, even if there was an issue about the statute of frauds, and I'm not saying there is, how does your argument not fail on real property law 442D, which clearly seems to be applicable here?
I'd like, in connection with that question, Your Honor, I'd like to point this court to its own ruling from 2007, the Advisory Services case versus Silver Bar Holding, the reporter's 38 AD 3rd 241. The facts of that case are strikingly similar to the facts here, and I'll just give a very brief overview. In connection with that case, under the parties' agreement, the plaintiff, or it was the plaintiff's assignor, was hired to, among other things, introduce a defendant to multiple capital sources for the purpose of facilitating a real estate transaction. There is no dispute that the individual was not a broker in that case. However, the defendants in that case argued under RPL 442D that because he's not a duly licensed real estate broker, he had no capacity to sue, and therefore the complaint should have been barred under CPLR 3211A3.
Is that a 442D case?
That's a 442D case. It is, Your Honor.
Which department?
First Department, Your Honor.
When?
2007. It's still valid law. And I'd also just like to point out, they said that the plaintiff in that case had no capacity to sue under CPLR 3211A3. That is the same argument that Mr. Coffin makes on page 35 of his opposition. And rejecting this argument, I'd like to just point out what the lower court said, which this court affirmed. And the court rejected the argument under 442.
We'll look at the cases, counsel, because
Okay.
your time's up.
All right, fair enough. Thank you, Your Honors.
Thank you so much. Goon versus Grand Central Partnership.
Good afternoon, Your Honors. Kenneth Gorman for the plaintiff appellant. This case essentially boils down to whether the granite border was part of the sidewalk or the tree well. And
Sir, are you familiar with our case, Cabral versus Triangle LLC, issued in January?
Yes,
And you know, the exact same panel.
yes,
And it involves a tree well.
yes.
So it's strikingly identical to this case. And in that case, we determined what?
Well, in Cabral versus Triangle, we do discuss it at pages 7 to 8 of our reply brief, and this court noted that the metal tree guards surrounded the tree well's perimeter. And it was my impression that outside of the perimeter, which abutted the sidewalk, the owner was responsible for maintaining it under 7210. If you look at the pictures on the record on appeal in Cabral, you'll see the metal tree guard. It's right around the tree pit, and adjacent to the tree guard is the sidewalk.
Counsel, the granite border, however, was within the confines of the tree pit, was it not?
It was outside of the metal.
No, not my question. The tree pit has a given dimension. It's only but so big. I believe the tree pit was reconstructed at some point because there had been complaints about
Correct.
prior trips, right?
That's correct.
Trip and falls. And upon reconstruction, the one that we're talking about now is pink granite, and it's smaller in size than the original perimeter. Is that correct?
I'm not sure about that because the vertical differential for this particular granite border was 2 to 4 inches, which exceeds the half-inch maximum height differential that's permitted under the administrative
Was there any
code.
violation issued by DOT or DOB or?
No.
So was the tree pit in conformity with the existing regulations at the time that it was constructed?
I don't think it was.
Are you referring to the guidelines that came after the construction, I think 2008, 2009, something like that.
I don't, I think the granite borders were actually constructed as part of a sidewalk reconstruction project. I don't think it had anything to do with the tree pit itself. It was a decorative border designed for nothing other than to enhance the aesthetics of the area. It served no purpose. It didn't assist the tree pit. It prevented water from going into the tree pit, which Mr. PC states in his.
I don't know that that's scientifically true, that a border that's raised above the sidewalk would prevent water from staying in the tree pit, for example, if it rained. I mean, that was a very interesting argument that you posed, just as was the optical illusion one, which was kind of novel.
I don't think the optical illusion one was novel. I mean, the trial court's finding that the granite border was an optical illusion was based on photographs taken under optimal visible conditions during the day.
But the sidewalk was gray, right? The sidewalks in the city of New York are kind of gray.
Yes.
And
yes.
the border was, this granite border was pink granite, am I right?
I'd like to refer you to pages 930.
I looked at the photographs. I'm talking about what I saw.
Okay.
It's different, right? One color from the other?
It depends how you look at it. If you're looking at it on top, yes, I can imagine. But if you're walking toward it at night with visible conditions like this case, there was no lighting.
Is there any code set up that says you must design a border at such and such a height in order to avoid people colliding with it?
Well, that's why we argued Section 152 and Highway Rule Section 2-09, which
They refer to sidewalks, right? Not to tree pits?
well, I mean, if it was part of the tree pit.
No. The sections that you cite, that you say have been violated, refer to sidewalks, right?
Most of them, not all.
Which ones refer to tree pits?
209, subdivision F4XXD, which requires any paved surface in the tree pit to be flush with the sidewalk, which did not occur here.
Was that in effect at the time that this border was created?
I thought it was, but I can't answer that for sure. I can't give you a definite answer.
Okay.
Thank you.
Thank you.
Good afternoon, Your Honors. Richard Freire of Pillinger Miller Torello for the respondent Grand Central Partnership. This exact panel's decision earlier this year is dispositive in this case. And to Your Honor's question regarding whether the border was part of the tree pit, it clearly is. It's part of the footprint of that tree pit. The fact that it was installed at some point, if anything, it just highlights the fact that this occurred within the footprint of the tree pit itself.
What import should we give, if any, to the fact that there wasn't a tree in the tree well?
None, Your Honor, because it has nothing to do with the plaintiff's claim other than to perhaps claim an optical illusion that would fly in the face of the photos in this case. It is a pink granite border outlined by a black fence filled with red mulch adjacent to gray cement. There's no optical illusion here. Even that theory is applicable, if at all, in cases involving different elevations where there's some reason for an optical illusion to then cause someone to not perceive that they were coming from one elevation to another. That's not the case here. In fact, the plaintiff admitted at her deposition that she saw the black fence about 20 feet away before she even got to the subject area.
What about counsel's argument that some of the regulations did involve tree wells and not sidewalks?
By their own language, they don't involve the actual border. And I would point out that the ordinances and the provisions that plaintiff does rely on are not applicable because insofar as they pertain to sidewalk appurtenances and hardware, this is not part of the sidewalk. To call this granite border an appurtenance to the sidewalk or sidewalk hardware is directly contradicting not only the language of the codes themselves, but decisions, case law, including the King case, which clearly enunciates that those codes were meant for objects that by their design were meant to handle pedestrian traffic. So they were meant to avoid tripping hazards. Otherwise, if this is an appurtenance, then so is a newspaper stand, so is a hydrant, so is any bus stop, any number of things, because those are not sidewalk hardware or appurtenances. Those are all meant because you intend, or at least you contemplate, that people are going to walk over those items. You're not meant to walk into a tree pit, you're not meant to walk over a border, you're not meant to walk into a border.
So what about the argument that the border was supposed to be flat, flush with the sidewalk? As would be a grading, for example, or cobblestones?
That presumes that it was part of the sidewalk or an appurtenance. This border is permissible under the park and regulations that are applicable to tree wells. The decorative tree borders are permitted, and in fact, plaintiff does not allege that the applicable codes for the parks and regulation that permit certain decorative tree borders were not complied with.
Were you required to get a permit before installing the border?
I apologize, Your Honor. I don't know the.
No, I don't know the answer.
I don't know whether that's in the record,
I don't know the
Your Honor.
answer either.
But I will reiterate that, as Your Honor pointed out, there is no evidence of any violations or citations with respect to this border after it was installed. Thank you, Your Honor.
So much.
Good afternoon, Michael Lenoff for the abutting property owner Bernhard Levinson. On top of everything else the attorney said, mentioned for Grand Central, my client didn't design it, we didn't maintain it, we didn't change the border. It had originally been cobblestones, we had no responsibility then, and for the Grand Central to change it, and all of a sudden my client now becomes responsible because of that change would be manifestly unfair. So I have nothing else to add unless you have questions for me.
Thank you. Anyone have questions? Thank you.
Good afternoon, Your Honors, and may it please the Court. I'm Alan Rosinas, I represent the respondent, City of New York. Your Honors, the city's position here is very simple. The only issue as to the city is whether or not the court acted prematurely in granting summary judgment to the city. The plaintiffs allege that they wanted to call a witness to talk about the removal of the tree from the tree well. But here, the plaintiff testified very clearly that she saw the tree well on the tree, as my colleague said, 10 seconds before she fell. She continued to see the tree well, the tree guard 5 seconds before she fell. So there's no basis here on which to, the only way that the removal of a tree could be relevant, as the plaintiff's own expert said, is where the removal of a tree well meant that you couldn't see the tree, you weren't aware of the tree well or the tree guard.
So in other words, your friend is claiming liability because a tree wasn't there and you had a duty to plant a tree.
What about planting a tree, Your Honor? I'm sorry?
Is he claiming the city had a duty to plant a tree and therefore the absence of planting trees caused this accident?
I mean, I think you could. I think one could infer yes, because the expert. One of the things his expert said was there should have been other plantings, either I guess by the owners or by the city. But again, the point here, Your Honor, is that she saw the tree well and she saw the tree guard. So that's just not material in this case. In another case where she didn't see anything, including the tree well or the tree guard, it might be pertinent. But here it's not, because the only thing she didn't see was the stone enclosure. She saw the tree well and the tree guard. And it's worth noting finally, Your Honors, that we made this detailed argument in our brief, and in her reply brief, in the plaintiff, two plaintiffs, her and her husband, in the plaintiff's reply brief, they didn't respond at all to our detailed factual points about the main plaintiff's testimony. That they just reasserted their conclusory allegations about the prematurity because of this witness they wanted. But the witness couldn't have given material testimony here, Your Honors, and that's why the city, summary judgment as the city, should be affirmed.
Counsel, did the granite border exceed the perimeter of the original tree pit?
I mean, I think, I don't know, Your Honor. That isn't a fact that's relevant to the city's liability, but I guess I would, so what I'm about to say is kind of speculation, but looking at the photographs, as I understand it, there is the tree well or the tree pit, and then there's a tree guard around that, the tree well or the tree pit, and then around the tree guard is the stone enclosure. So I would guess that yes, it's the perimeter or the size of the stone enclosure is greater than the size of the tree well. But again, as far as I can tell, it's not relevant to the city's position. I'm just saying based on my own observation of the photographs.
Is there any case that has held that that the city is required to replace a tree with a tree?
No, not that I'm aware of, Your Honor. And, you know, again, here, I don't see how there could be a requirement here where, you know, the only question here is whether the city itself, because the private notice is not an issue, the only question is whether the city itself caused or created an imminent hazard. And the only way that could happen here is if, by removing the tree, it somehow caused or at least contributed to causation of the accident. And
Thank you.
because, yes,
Thank you very
thank
much.
you, Your Honors.
Just briefly, I want to refer the court to the Second Department's decision in Abu Hamda versus Brooklyn Sneaker. We discussed it at pages 8 to 9 of our reply brief. In that case, the Second Department held that the raised granite decorated bricks that were used to highlight the tree wells was part of the sidewalk for purposes of 7210. And I don't think anybody could dispute that this was a tripping hazard. Even GCP's own general counsel admitted that this posed a tripping hazard when there was no tree in the tree well. It didn't give the pedestrians the visual notification that they needed to make the appropriate precautions when walking.
Counsel, how could that be? Because the plaintiff said she saw the metal, excuse me, the metal fence, you know, the tree well, about 10 seconds before she fell. And the only reason why she had her accident was because the sidewalk and the granite border were the same color, which looks a little different to me. Two different colors, but that's what she said as to the only reason why she fell. The tree had nothing to do with it. Nothing. As what she said.
Well, yeah, I mean, she's not going to recognize if a tree is going to bring attention to it. She's just a pedestrian.
But she said the only reason, see, I got that. The only reason why she had her accident was because that granite was the same color as the sidewalk. And when I look at it, it's different. Color's different.
When you look at it from that perspective, maybe. But when you're looking at it, when you're walking towards it, you know, when you're looking at the photos at 9:30 to 9:36 of the record, it doesn't look as different as some of the photos. And
Thank
it
you.
does. Okay.
Thank you very much.
Thank you.
People versus Judah. I apologize in advance if I mispronounced his name.
I'm not sure how to pronounce it.
I'm not sure
I
either.
say Jude. So, may it please the court, my name is Paul Wiener, appearing for appellant Akram Jude. Mr. Jude's right to present a defense and to cross-examine the witnesses were violated here. The only disputed issue in this case is whether he struck the detective intentionally or whether he was guilty of reckless assault. The main proof of intent came from the testimony of the 3 officers who shot him 10 times. They fired a total of 18 shots in a crowded...
So it's undisputed that they shot him after the incident occurred, correct? At the time they shot him, the incident for which he was charged had already occurred. The attack had already occurred. Is that right?
That's correct, Your Honor.
So, particularly in light of the fact that the investigation concluded that there was no wrongdoing on the part of the officers in shooting him, what relevance would this testimony have had to the case? It doesn't go to anything that he did before the shooting began. So what's the relevance?
It goes potentially to a motive to fabricate or a motive to exaggerate.
Counsel, isn't that a little far-fetched that they would have a motive to exaggerate? Because the only reason they could potentially have a motive is that they're worried about a disciplinary proceeding, but there was no disciplinary proceeding.
But at the time they gave their statements before the investigation.
Well, what about the actual police officer who was attacked? He also gave that testimony. What would be his motivation?
Well, I mean, his testimony, I think, is a lot weaker. I mean, he talked to the other officers at the hospital. He also didn't see. He also testified that he didn't see himself being hit with the
Counsel,
cleaver.
there was evidence that there were, I think, 15 shots fired, or at least 15 casings recovered. You wanted to get in evidence that there were 18. What's the difference? And please don't tell me 3.
All right. Well, I think, look, the more shots, they fired 8 shots. That didn't hit the target. They hit another officer. They hit 2 cars. This was a very serious incident. I just want to go back.
Counsel, but we've got videotape and we've got testimony, and your main focus is reason to fabricate, right? I mean, that's kind of the overriding theory. They had a reason to fabricate. So here you have someone who can't exactly say, I saw when the meat cleaver hit my face. I'm sorry, I'm touching the top of my head, but I should be touching the side of my face, and gave me a slash that was, they say 7 inches. It looked like more than 7 inches, but 100 stitches. And then you have this man running through the streets with a meat cleaver. What time of day was this? Was this midday or something? And wasn't it a very crowded area?
It was. But
So we see the video, we have the testimony, and it's crowded. The location is a busy New York street, right? So like my colleagues have been saying, your thrust is that there needed to be cross-examination about past disciplinary investigations that produced 0 results?
But at the time they made the statements before the investigation, they didn't know how the investigation would turn out. This was a very serious formal investigation. It was helmed by the Force Investigation Division. They were given lawyers. They had to make statements. They didn't know how it was going to turn out. And so they essentially locked in their version of the events at that time. Yes, they were ultimately exonerated, but they didn't know that at the time. So they couldn't obviously give a different version of events later. That was the story. And they had every incentive, given the serious discipline that they faced. They could have lost their jobs. They could have even potentially have lost their liberty.
Did the defendant drop the cleaver when he was stopped by the police door of the car, the police car door, or did he still have the cleaver in hand? What happened at that point?
He had the cleaver, but I'm sorry, you're talking about at the beginning of the incident or the end? The end of the incident. I don't know. I mean, the defense was that he was guilty of reckless assault for running through the streets with the cleaver. There's no question he's guilty of a crime. The detective, who was acting heroically, but barreled into him, collided with him, and made contact with the cleaver. And the main.
Yes, I'm going to interrupt for a second. Your argument is based on us accepting that 4 different officers and the victim all fabricated testimony about what happened in order to avoid potential disciplinary consequences. Doesn't that seem somewhat unfeasible?
Well, first of all, I don't think the detective talked to the others, so I don't think that nobody's suggesting that he may have possibly fabricated.
Okay, so 4 officers all fabricating testimony.
It's the 3
based on this alleged disciplinary consequences, which never even happened. And they were defending an officer who had already been attacked by an assailant with a cleaver who hit him in the head. I mean, doesn't that seem far-fetched?
No, it isn't, because they had every reason to make Mr. Jude seem much more dangerous.
How could he seem much more dangerous than he was, based on what he actually did? That's pretty dangerous.
Because the difference is he was running through the streets, he was holding the cleaver, he shouldn't have been holding the cleaver, and he's guilty of reckless assault.
And he hit the police officer with the cleaver.
Well, the cleaver made contact with the police.
No, it didn't make contact with him because there were some serious injuries. I mean, serious, life-threatening injuries. And normally, you don't have those kind of injuries because you come into contact.
It was very serious injuries. He was.
Thank you. You have time on rebuttal. Thank you.
Okay.
Good afternoon, Your Honors, and may it please the Court. Stacey Nadell for the people.
This was, if I can, we know that there were the officers, right? But wasn't there a witness that I believe called 911 3 times about what was going on with the defendant?
There was, Your Honor. So the witness who called 911 3 times did so when the defendant was trying to take the parking boot off of his car and then filmed an initial interaction with the police. But this was, I believe the filming stopped when the defendant started running away. So this was before the slashing of Detective O'Donnell. And to your point, Your Honor, there were other witnesses other than the police officer. The police officer's testimony all corroborated each other, as well as the victims who really had no motive to fabricate anything here. And what really this boils down to is that this was a valid exercise of discretion by the trial court in curtailing the scope of the defendant's cross-examination, because whatever little probative value this desired cross-examination might have had was far outweighed by the risks of confusing the jury, misleading the jury, because the practical effect of this cross-examination was that we would be relitigating the force issue that had been dealt with and settled prior. So essentially, the probative value was slight, if any, and was far outweighed by this. And in any event, the defense was allowed to probe this theory of witness bias, which is, the defense is always allowed to pursue theories of witness bias that they might have, and the defense was allowed to do so here, both on cross-examination and in summation. So this theory was put before the jury.
So undoubtedly, the injuries here are significant.
Yes.
With that said, the defendant has shown to have substantial mental health history. How does that play into the sentencing?
The defendant's mental health history was put squarely before the sentencing court, and the sentencing court fully considered it. The same judge who presided over the sentencing proceeding presided over the trial and defendant's 730 examination, so he was intimately familiar with the defendant's mental health issues and fashioned that into the sentence, which I would like to note is 5 years below the maximum. And
it's 4 times over the minimum, correct?
Correct. But as Your Honor mentioned, the injuries here were severe, and there was a huge risk that there could be life-threatening injuries to other people based on the time of day, the location.
He's running down the street with a meat cleaver in his hand in the city.
Correct. Yes.
That's a recipe for disaster.
That is correct, Your Honor. So
the shots are fired at which point? It's when the defendant is he's stopped by the police door, police car door. And what does he do with the cleaver at that point? Does he drop it or does he advance towards the police?
There's testimony that the defendant was waving the meat cleaver above his head and advancing towards the officers who were prepared to subdue the defendant.
And that's after the meat cleaver made contact, as counsel says, with the victim, correct?
Correct, yes. And so the cleaver was over the defendant's head. The officers fired their shots, and the cleaver sort of went down with the defendant. And I believe it was Lieutenant Brandy testified that he had stepped on the cleaver once it fell out of the defendant's hand when he was going in to make the arrest. And if Your Honors have no further questions, we ask that you affirm.
Thank you.
Thank you.
I'd just like to make a few points about this sentence. Mr. Jude is severely mentally ill. He is almost certainly schizophrenic. He is delusional. This is somebody who believed that President Obama and Mayor Bloomberg wanted to be on his racing team. He had been in and out of Bellevue Hospital numerous times for mental health observations. He was homeless, which undoubtedly aggravated his mental health condition. And clearly, when he was running down the street holding the meat cleaver, he was delusional and was not in his right mind. He also, at sentencing, expressed, 3 times, he said, "I am sorry for the injuries that I have caused." And he also suffered life-altering injuries. He got 6 or 7 bullets in him. He had his spleen removed. He can't walk. Given all of this,
Counsel, was there a mental insanity, not guilty by reason of mental insanity defense raised here?
There wasn't, and I think the lawyers strongly considered it, but they decided to go with the intent versus non-intent, and that was the lawyer's call. But there's no question, this is well documented that he is schizophrenic, he's homeless, and to give him a sentence that's close to the maximum sentence here. 20 years in prison is really excessive, and I would urge the court to please reduce the sentence. Thank you so much.
Thank you. McCoy versus Lavski.
Good afternoon, Your Honors. May it please the court. Rebecca Viscatus for the New York City Department of Social Services. Supreme Court's order should be reversed because it has no support in the governing statutes, relevant precedent, or the record.
So essentially, the court below sort of conflated 104B of the social service law with 369.
I think so, yes.
And somehow construed a claim as a lien.
Yes, that seems
And that was the error here.
Yes.
Which means that you had a full right, presumably to the entire settlement, arguably.
Yes, I mean, the DSS had a claim under 369 for the full amount of Medicaid assistance provided to the decedent when she was 55 or older.
Which would be unrelated to any medical treatment for these particular injuries.
That's exactly right.
And you chose, as you were entitled to assert this claim in surrogate's court rather than in the actual proceeding because you were not limiting the recovery to anything that was recovered in these proceedings.
That's exactly right. And DSS was not only entitled to do that, but required by the relevant statute.
That's what I was going to ask you about. So was there an option for DSS to say something like, we don't want to go forward, we don't want this person's money, she's deceased, let her family have it? Was that an option?
Not under the statute. In practice, when DSS brings these claims in surrogate's court, there is often some sort of settlement procedure, and I cannot
There was
speak
some sort
to
of an offer here, correct?
Right, there was a settlement offer here, and it was because in that context, DSS often does look at the full situation and the amount of the estate. This is not some sort of attempt for DSS to get money that it's not entitled to or to leave family members destitute. It's simply DSS's obligation under state and federal law to attempt to recoup what it has paid for Medicaid assistance to someone after
your claim went 10 years back as far as the services that were provided, not only with respect to the immediate hospitalization. Is that right?
That's exactly right, yes.
And if you were bringing this type of claim, you would not be intervening in a personal injury action in the state court. You would be bringing it in surrogate's court as part of the estate proceedings.
Right, which is exactly what we were doing in this case. Supreme Court said that we chose to pursue this before Supreme Court in the medical malpractice action. That's simply untrue.
So you're asking to go back to where you were originally, which is to not resolve anything in this personal injury action, to not give up any rights in this personal injury action, and to proceed in surrogate's court as you originally planned to pursue your claim there under 369.
That is
That's what you're
exactly right.
seeking.
That is exactly.
Counsel, if the settlement here had been for wrongful death, DSS would not have a claim, correct?
If it had been for wrongful death, right, that would not be part of the estate that would be subject to DSS's claim. But as we argue in our brief, there was no record support for an allocation of.
And doesn't plaintiff allege in surrogate court that the settlement was for pain and suffering?
Yes, the plaintiff alleged that the settlement was for pain and suffering, and as we pointed out in his submissions in this motion before Supreme Court, laid out all of the pain and suffering that the decedent went through and essentially gave no basis for a wrongful death settlement.
And counsel, the only reason why you even got to Supreme Court was because the two defendants moved to compel DSS to compromise and to withdraw any lien, but there was never a lien. It was actually a claim that was filed.
That's correct.
Okay, I think we got it.
Thank you, Your Honors.
Thank you.
May it please the court, Stephen Sachs for the plaintiff respondent, McCoy.
What's wrong with everything she said?
Well, it's inconsistent. That's where we can start. They're acknowledging that they're not entitled to any recovery from the wrongful death portion of any settlement in this case. At the same time, they want the entire recovery
Counsel, when has a record ever been made in this proceeding that any of the recovery was for wrongful death? And how could you even make, I'm asking you two questions, how could you even make that claim where your submissions to the surrogates court were only for pain and suffering and never for wrongful death? So what's wrong with what she's saying? If it is all pain and suffering and not wrongful death, then she is, not she, DSS is entitled to 100% of the proceeds.
So I can answer both of those questions if you give me just one moment. The court below, specifically in its order, said that they were considering, under the cases that have come before in the lower courts, whether there was wrongful death or pain and suffering here. That they did discuss Alborn. The judge also discussed.
Did the court actually make any determination below as to what the claim was for in making her determination that DSS had to compromise the claim?
So it's unclear exactly what the determination.
Because she never made a determination, right?
But the order does say that she considered whether there was wrongful death
Okay,
or
well,
pain
putting
and
that
suffering.
aside, how do you address your own submissions in surrogate court that the recovery was for totally for pain and suffering, and you actually moved to discontinue the cause of action for wrongful death in surrogate's court? So doesn't that support DSS's argument in this case 100%?
On page 79 of the appendix are the bills of particulars in this case, specifically on page 80.
We're way past the bills of particular here. We're talking about what you did in surrogate's court. How are you addressing the filing that you made in surrogate's court saying this is not a wrongful death claim, it's a pain and suffering claim? That's the operative thing we're dealing with here, not the bill of particulars.
Well, the Supreme Court and the surrogate court have concurrent jurisdiction. The surrogate court filing had come some point after and probably needs to be amended accordingly.
That's the position you took in this litigation, that it is a wrong, and the court below actually, even though it never made a determination, she basically acknowledged in the proceedings that this was really a pain and suffering claim, and it could not really be a wrongful death claim. So I don't see where in this case you're getting support for the argument that this is really a wrongful death rather than a pain and suffering.
I'm not sure that's what the court below said. The court below did say that this was a period of pain and suffering for 70 some odd days, 2.5 months. And then—
Wait, I'm reading. Supreme Court itself acknowledged that under the circumstances presented here involving an action for pain and suffering, the entire recovery would be taken by claim against the estate. So she actually made a determination that this really was pain and suffering. That's what she said in the record.
I don't think that's what she said, because she later says that she's considering whether it's pain and suffering and wrongful death, awards a specific amount to DSS as a result, which would have compromised the pain and suffering portion of the recovery.
Well, Counsel, you would agree that this was originally a medical malpractice wrongful death case, that, and in negotiating with the hospital and the doctors, you were essentially seeking you ultimately settled for $325,000 from a so-called $800,000 demand. That was for pain and suffering. That wasn't for wrongful death, correct?
Well, the settlement—
You wouldn't get that kind of money here for wrongful death.
The settlement does not, and the settlement documents that we anticipate do not delineate what causes of action were settled for what.
Well, let's go to what he said. What viability would there be for a wrongful death claim in this case where someone who'd been so ill for so long was not earning any income? What viable wrongful death claim was there? How could any court possibly allocate anything but a de minimis amount of this claim to wrongful death rather than pain and suffering?
As was stated—
Which is what my colleague was referring to.
Yes. As was stated in the bill of particulars, there are claims for the 3 children's loss of guidance that they sustained from the decedent's death. And if you compare that to the 70 or so days of the pain and suffering, a court can easily come to a conclusion that there is a larger wrongful death
No,
component.
none of this argument is in the record below, though. This is all an argument you're making now.
No, that's in our
before-
brief.
Here,
Yes,
not below. Thank you.
thank you. Good afternoon, Your Honors. May it please the court, I'm Jason Turkin, and I represent respondents Dr. Lavski and Bronx Lebanon Hospital Center. Ironically, I may be the only one here who believes that the wrongful death issue is just a red herring, because I think to get to that, you first have to assume that DSS is absolutely right. If it's a pain and suffering case, they can do whatever they like, whenever they like, under the statute.
Well, they can't do whatever they like. They can bring a claim in surrogate's court and assert a claim for the last 10 years.
Agreed, Your Honor.
Unrelated to this particular case.
They can and they did.
Correct.
But if a Supreme Court case gets to its conclusion years earlier, as in this case, then DSS gets its matter heard in the surrogate's court, Supreme Court has to do something. And, you know, the case existed for many years. And
How can Supreme Court have the authority to take away from DSS a statutory right that unambiguously belongs to DSS?
I can answer that, Your Honor.
Go ahead.
There's a statutory right to seek the replenishment of the Medicaid expenses. And DSS did that, and they state, look at the statute. We agree that the statute says that they should try to get it all back if it can be gotten back. But the statute doesn't say you can get it all back if the money isn't there.
Well, they can only get what they can get, but what this court tried to do was to say you have to compromise your claim, and how can, even if they had extensive authority to hear the claim, which maybe they do because there's extensive, co-authority, how do they have the authority to say to DSS, hey, you have this claim under the statute. The claim under the statute is not limited in any way to this particular accident. It's for 10 years of services. Compromise your claim and settle it for less. How can a court order DSS to do that?
If we all agreed that the statute mandates them to seek all the money back, and that's all you can do. You even DSS under the statute, you have no discretion. You have
No, it's not saying DSS doesn't have discretion. It's saying that DSS has the right. DSS can decide not to pursue its claim. It's not being forced to pursue its claim, but it has the right to pursue its claim. The court doesn't have the authority, arguably, under the statute to force DSS to give up its claim,
Your Honor,
which is a different issue than whether DSS can agree to give up.
We think the circumstances matter. So DSS was trying to, unbeknownst to us at the time, DSS was apparently trying to negotiate the case and even sought $102,000.
Which it's allowed to do.
It's allowed to do it, but it indicates that it doesn't think its hands are tied, that it's mandated to get $893,000.
No, counsel, you're not addressing the distinction I'm making, which is whether DSS has the power itself to compromise its claim, which is not a lien, its claim, versus whether the court has the authority to force DSS. Where under the statute does the court have the authority to say, DSS, even though you have this statutory right, we're forcing you to compromise?
I don't think the court out of the blue can just come and try to force it.
Isn't that what happened in this case?
I don't think so. I think in the situation where a Supreme Court case comes to this point, something has to bend because they're the rights of all the parties in the Supreme Court action. Why does it
have to bend? If the statute says DSS has the right to do this, why does the court have the authority to force DSS to bend?
Because the court has the discretion just as to the proceeds of its case, not if the estate were to found to also have won the lottery. There's something said in the DSS's brief about the lottery winnings. If there were other funds there, the court.
You're saying the court could do it. You're saying the court could do whatever it wants to force a settlement in a case before. Is that the argument?
I'm saying as to the proceeds in the case before this court, it has the right to bring an end to the action where the parties are already negotiating.
Where does the law say that under the law that allows DSS to go to surrogates courts? Where does it say that a court, whether it be the surrogates court or the Supreme Court, have the authority to force the DSS to compromise its surrogate court claim against the estate in order to settle a personal injury claim?
The law doesn't
Those words don't exist, Your Honor. They don't. But the law also doesn't say you're mandated to get back the whole thing and there are no other options here. It just doesn't make sense. Cases can't get to an end.
It's a problem. That's why DSS was willing to compromise. Thank you.
Thank you.
Your Honor, I don't have much to add. I think this is a situation where we can see from Supreme Court's decision that it was grasping for authority to shield the settlement from DSS and from the surrogates court proceeding, and it simply had no basis to do that under the law. I'm happy
What
to
would
answer.
your remedy have been, just to follow through all these arguments, if the court had taken the position that 100% of the proceeds were wrongful death? Would you have had any remedy to challenge that?
That 100% were wrongful death and that DSS was not entitled to anything? I think it would depend if we had not been dragged into this case, then I'm not sure if we would have been aware until it got before surrogates court and we realized the amount of the estate was less than expected after the settlement. But I think that that could be a situation where DSS would intervene if it was this stark of a record, where it was very clear that there was no basis for a wrongful death allocation at all. Then it's possible DSS would have sought to prevent that in the first place.
Thank you.
Thank you.
American Infertility of New York versus Kushner. Counsel, before we begin, you were not here for the call of the calendar. I was extremely tempted to give you no argument time because everybody else manages to come for the call of the calendar. You're required to come for the call of the calendar, and arguably you've waived any rights by not appearing at the call of the calendar.
I understand.
And I'm going to give you 2 minutes to state what you wish with no rebuttal time. But in the future, if you're here again, you need to get here at the call.
I apologize, Your Honor.
Everybody else. Or
May it
don't
please-
come. Either way.
May it please the court, Your Honor, Stephen Turman for appellant, American Infertility of New York. We seek reversal of judgment that was awarded in respondent's favor, an amount of in excess of $550,000. The first basis for the reversal would be
Well, you're aware that your principal conceded or admitted that he didn't pay him the salary that he was entitled to after that temporary situation.
That's
admitted.
not what he didn't say that, Your Honor. What he said, he deferred first to his COO, who's responsible for the payroll, and he believed that the payroll had been restored. This is not and to be clear, we're talking about this is on the $81,000 aspect of it, which was the section 19. This wasn't on the weekend work. Is that correct?
No, I'm talking about the actual work.
Well,
there was a request to temporarily reduce it with the promise that it will be restored.
Correct.
And the principal thought it was, but he admitted at the end if it wasn't restored, he was entitled to it. Correct?
Then the record shows that it wasn't. It was ultimately restored in late 2018, after the respondent had already put in his notice of resignation. There may be a month or two, but the point here was that it wasn't on. That would have still been on a contract basis. Here, the court ruled on that element on section 190 on Labor Law 193 that it was a violation of Labor Law 193, and that deals with withholding of earned wages, not under the contract. She didn't make any finding under the contract other than the fact that that she didn't apply it. So it was on. She applied prospective wages to an agreement that was reached in 2015 for a wage reduction. So.
Thank you. I'm sorry, you done answering that question?
No, yes, Your Honor.
Thank you.
Okay.
Good afternoon, Your Honor. May it please the court? Sorry. Charles Liebman on behalf of respondent Dr. Vitaly Kushner. I don't want it to get lost on the court that testimony on this case ended on December 2nd of 2021. There was submissions by both parties as to written a brief on facts and law in August of 2022. A decision was rendered in October of 2022. and a motion to correct was filed by appellant in November of 2022. The appellant has had 3 bites at the apple to make any of the objections made in this brief. None of them were ever raised. They were not raised at court or thereafter. They were waived. These are all factual issues that could have been raised dealing with the intent of the parties in contract, and they were not.
One of the issues raised by your friend was that they were entitled to get the dividends or the demutualization consideration because they were paying the premium, correct?
That was the appellant's argument.
Right.
And the Court of Appeals found otherwise.
In Hines, which
Correct.
makes it clear that as the policyholder, your client was entitled to the dividends.
100%, Your Honor. That was the decision. I also just want to touch quickly on one issue, which it might get lost in the issue of quasi-contract. And counsel argues several times that because there was a contract, there is no basis for allowance for weekend work because it's not quasi-contract. A contract exists if I do something like hire a painter and I say, I'll give you $50 to paint a wall in my room. Quasi-contract is if after he starts working, I say, I'd like you to paint the other 2 walls as well. It's not in the contract as to how the remuneration would occur if I wanted extras. In this case, Dr. Kushner was required by his contract to work 1 of every 3 weekends. He, in fact, was required to work 1 of every 2. We pled it. We asked for the remuneration, and the Court of Appeal specifically states in the cases we cited that, and in fact, the case that appellant cited, that when you have a situation where the contract does not specifically address alterations or remuneration, if there is an alteration, then you have a quasi-contract, and the reason for that is you want to prevent unjust enrichment of a party. So the case law is very clear from the Court of Appeals that this is a case where extra weekend work should be awarded funds based on the existence of the work. And it was testified by the COO, not only that he did the work, but she provided the valuation of the work. There's no greater determination as to the value of a good or service than the market. And the market in this case is the services of a reproductive endocrinologist.
Counsel, what's in the record to substantiate the $13,000 award for pension contribution?
The pension contribution was based on, actually the judge departed from what the other doctors get and gave Dr. Kushner less than what the other doctors got. They got $50,000 a year for that benefit. In the initial year that it was paid, which was the 2nd year, Dr. Kushner only received $13, and the judge decided that because it was a single year, 1-year contract, and that 1-year contract required he be paid a benefit, that she followed the practice of appellant that awarded $13,000 in the 2nd year to say, you were contractually obligated to provide a benefit. You didn't do that. I'm going to calculate that the amount you should have paid is what you actually paid.
Year? Are we talking about year 2?
Yes.
Or about year 1? Do you concede that no contribution, that the defendant was not entitled to the $13,000 for year 1?
No, he was entitled to that because it was a singular year contract and it stated he would be provided that benefit. What's odd in this case is that there was in fact no pension at all at the practice. He said he would provide a pension benefit. There was no pension. There was a profit-sharing plan that was administered by a third party.
Okay, thank you very much.
Thank you so much.
Our last case, People versus Lounis.
Good afternoon, Your Honors. David Clem for Appellant Kareem Loundis. My wife thinks my college friends are a bit disreputable, and I'm sure she points to a lot of injurious behavior that I engage in. But I would guess none of us...
I guess that goes to your vagueness argument?
Excuse me?
I guess that goes to your vagueness argument?
This would be my vagueness argument. I would guess none of us would think that that's a basis for incarceration.
How do we get to address the vagueness argument under the circumstances of this case, assuming we find there's a valid waiver of the right to appeal? How would we reach this? And also that the claims aren't preserved, these arguments were not made below. Is the only basis for us to reach them is your argument in the interest of justice we should reach them?
Not at all. This court in a series of cases, including Alvarez in 2024, Amparo in 2025, all based on the Court of Appeals' decision in Hakes in 2018, has made it very clear that conditions of probation constitute, if they're illegal or improper, constitute an illegal sentence that's immune and exempt from the preservation requirement and can be reviewed in the first instance in this court.
Well, I'm still struck by the whole argument. Would you not agree that Condition 7 of the probation, of probation, which I interpret as avoid bad habits, bad people, and bad places, and that can be reasonably related to his rehabilitation? Would you not agree with that?
I can't agree with that. I'm sorry. Bad is a great word to use. I think it does mean that. It means don't do bad things. I just don't think that could be a probation condition that could subject someone to incarceration because...
Counsel, let me just... I assume you would agree that there is a difference between the probation condition being reasonably related versus the probation condition being vague.
Yes.
Okay. So in that regard, when my colleague says that the condition, basically the condition is, I think a reasonable person would conclude that don't commit crimes, don't hang out with people that commit crimes, and don't hang out with places where crimes are being committed. If that's the import of it, then that's reasonably related, right? Because in this case, the allegation was that they recovered a gun. He's not a gun maker, right? So he got it from somewhere. They recovered narcotics. Again, unless he's growing it in his backyard, he got it from somewhere. So if you want him to stay the course, stay away from people that sell guns. Stay away from people that have drugs. Well, how is that not reasonably related? We're not talking about vagueness. That's another issue.
I mean, I have to challenge you on that interpretation of it because there's a separate condition, Condition 8, which addresses that, which says don't hang out, don't do crimes. Be lawful.
And also, just to interject so you could answer it as well, the language that's used as part of Condition 7 is in the statute, right? That's what the court is supposed to think about when imposing the conditions, right?
Yes.
So isn't that something that supports imposing the condition then?
I mean, it certainly doesn't address the constitutionality of the condition at all.
Separate issue.
But it is, and it doesn't address factually whether it's related to Mr. Lounis's conviction. And the two are intertwined here. It's very hard to say that this is related to his rehabilitation when the language in it is potentially so broad and so restrictive as to who he could hang out with, where he could go, and really what he could do. And
your remedy for that would be to eliminate this language entirely or to rewrite it? Do you see any value in an order that's, well, it is an order, it's a condition, that requires someone to stay away from disreputable places? Is there any value to asking someone to walk a straight line?
There definitely is, and I'd point to the Second Department case from 2022 that...
How would you remedy this then? Would you simply eliminate Condition 7? Do you think it's violative of the Constitution then?
In the Hancarrick case from the Second Department, the condition was this. It was, you can't consort with disreputable people, including those under probation or parole supervision. So those types of modifications, I think, are appropriate here. What we can't have is this vague, undefined condition. So the condition that the Second Department upheld, which my friend cites to, is really very different and is lawful. That wouldn't be challenged. That is an appropriate condition, but it can't be that it's appropriate to don't do bad things.
Thank you. You have
That
time
just
on
can't
rebuttal.
be the condition.
Good afternoon, Your Honors. May it please the Court. Noah J. Sexton for the people.
Could you start by addressing the vagueness issue, and first of all, our ability to review it in the first instance on this record?
Of course, Your Honor, and I would point out that, frankly, in terms of regarding the probation conditions, either of them, there is no record. There's no record to work with. He's never raised any of these claims in any lower court. He has the ability to do so under CPL 41020, or if he thinks that this makes his entire sentence illegal, he can raise a 44020 claim. He can develop facts on the record related to this. He could bring in an expert with a dictionary. He could elucidate some kind of harm he's facing as a result of this.
Are you arguing that defendant cannot argue to this court that the condition imposed is unlawful? Because if it's an unlawful sentence, no preservation is needed, nothing's needed. He makes the argument.
His as-applied challenge in relation
That's
to
different.
the...
That's a constitutional challenge.
That's what I'm asking about, though.
That's what you're asking? Okay.
I'm asking about the vagueness constitutional challenge.
All right.
The unlawful sentence, yes, that cannot be waived, and
Because
the
I
court can...
I understood your question, but I heard you answer in terms of he could bring in the dictionary, and he could, he didn't make any of these arguments below. And while that may be true as to the constitutional part, with regards to the unlawful sentence part, doesn't have to make it below.
I should have been more clear. I was referring to the constitutional question. There's just simply not enough to make such a sweeping decision, which would essentially invalidate Penal Law 6510 1A and B, which is where these are
It wouldn't be as
codified.
applied, it would be on its face that it's unconstitutional.
Yes,
That's
and
not the challenge here is as applied, right?
he's making two arguments, but he is claiming as applied facially that it is unconstitutional. It is unconstitutional, void for vagueness, just by its nature. And if the court were to agree with that, it would functionally invalidate these provisions of the penal law, which, and I'm not saying this is dispositive, have been part of the penal law since 1967.
So counsel, your friend mentioned language that was different in the second department. Is this language in Condition 7 statutory, or does every district attorney or every department have the authority to create its own conditions of probation?
As far as I'm aware, these are set by statute. There might be some variations in the way that it's written down depending on what court you're in front of. These defendants are given a copy of the conditions of probation. It's a standard form after sentencing has happened. But it all boils down to that the court, according to the statute, can require a defendant to stay away from disreputable people or places, refrain from injurious or vicious habits. These are all set in statute. And fundamentally, to make such a sweeping determination on such a scant record, or I guess no record at all, would be fairly extreme, and this should be raised in a lower court. Thank you.
As I'm sure the court's aware, the conditions of probation form is handed to defendants and was handed to my client after sentence was imposed, as he waited in the courtroom. There was no mention of this condition beforehand. There is no opportunity at all.
Counsel, is this a boilerplate condition that's on that form, or was this a handwritten condition?
It was hand-checked off.
Hand-checked off, but it's pre-printed on the form.
In that form, there's a whole huge variation of different forms. There's not one.
The people said that this condition has been on the form since, I forgot what year, for a very long time. There's nothing special that you're arguing it's unconstitutionally vague here, other than on its face it's unconstitutional. So are you saying that this court in this decision on this record should make that kind of determination about this condition that's been in existence for so long unchallenged?
Yes, and it's
why is this the appropriate record where it wasn't raised below, there was no ability for arguments to be made? Why would this be the appropriate record to challenge that particular condition?
As I was saying before, there's no case where it can be objected to. It's not known if the clerk's going to check off this condition until afterwards. And what's the record for a facial challenge?
Usually the challenges are the reasonably related. I mean, those are the challenges we're normally dealing with when it comes to probation condition, not the constitutionally vague challenge.
It's because we've never seen anything like this. I mean, this language is so broad and sweeping, and we're not the first people saying this. I mean, the Sorge court early on looked at it, said, this condition is ridiculous and needs to be reconsidered by the legislature. What's weird is no one took up that invitation in the years since, and we are now. We're asking the court to look at it and strike it. This language...
Part of your general attack on conditions of probation.
This is a small condition of probation which is never enforced and shouldn't be used as a hang over our client's head. Thanks very much.